We have an interesting development in the San Antonio police officer's case, but before we get there, we're going to start with a little history. Here's what we're talking about today. There was a Texas resident by the name of Michael Morton, and in August of 1986, his wife, Christine Morton, was murdered in their home in Williamson County, Texas. Michael Morton was arrested, convicted, and in 1987 he was sentenced to life in prison for that murder. He consistently maintained his innocence. Crucially, during the prosecution, important evidence pointing to Morton's innocence was withheld by the state. For example, his young son's statement that another man committed the crime, a blood-stained bandana near the scene, and other investigative leads. After many years, DNA testing, which was obtained with help from the Innocence Project, great organization, finally linked the bandana to the wife and to another man, and Morton was exonerated in 2011 after about 25 years in the Texas penal system. Morton's case became emblematic of trial by ambush or prosecutorial non-disclosure and how it affected criminal justice in the state of Texas. The Texas bar not only took notice, the legislature did. They created the Michael Morton Act. The law took effect on January 1st, 2014 for offenses committed on or after that date. The act substantially amended the long-standing discovery statute. It removed good cause requirements for the defendant to show in order to get discovery under 3914. The statute moved to a request-based model rather than a motion-to-judge model. It mandated timely production upon a timely request by the defendant. The state must provide evidence material to any matter involved in the action, in the possession, custody, or control of the state or any person under contract with the state. It created Section 3914H, which required the state to automatically, even without a request, disclose any exculpatory, impeachment, or mitigating information that tends to negate guilt or reduce punishment. This is a freestanding duty. It defined the state broadly. The Act recognized that prosecutors' duties extend to items in law enforcement's possession or in their constructive possession, for example, something held by a contractor. And you don't think too often about contractors being somebody that the prosecution would use, but sometimes they do use expert witnesses, and that's a contractor. The Morton Act was designed to prevent wrongful convictions like Morton's by creating clear legislative duties on the state to disclose favorable, relevant evidence. It's not just due process, it's statutory. It shifts the burden rather than the defense having to show why it should get the evidence. The law assumes the defendant has a right once a timely request has been made. It aligns with broader reform efforts for transparency and standardization of the discovery process across Texas jurisdictions, reducing trial by surprise and enhancing fairness in criminal prosecutions. It sets the stage for later key decisions like Watkins versus State and State versus Heath that interpret and enforce its requirements. It's built on the model of Brady versus Maryland, the 1963 Supreme Court case. That case held that it was a due process violation not to turn over exculpatory evidence to the defendant. And of course, in Giglio, the court expanded that to be impeachment evidence. So if they know that a police officer has engaged in prior bad conduct, they have to provide that to the defendant. But the Michael Morton Act greatly expands the state's discovery duties under Brady. It imposes a request-based duty to disclose any relevant evidence, not just any impeachment evidence, any relevant evidence. It is an automatic continuing duty to disclose exculpatory, impeaching, or mitigating information, regardless of the request or perceived materiality. Watkins versus State is one of the key cases. It came out in 2021 and it defines material in 3914 as relevant, not Brady material. It holds that 3914 provides a statutory right broader than due process, and violations occur even without prejudice. Brady required prejudice in order to reverse a verdict. There's a witness that was left off of a disclosure form, but the state was never going to use them because they didn't have any relevant evidence. least that's what they thought. Well, in Texas, if they leave that witness off and the defense learns of that, that's a violation even without causing prejudice to the defendant. And then in State versus Heath, which is a 2024 case, it declares the disclosure to be the rule and non-disclosure the exception. It expands the state, like I said, to include prosecutors, law enforcement, and contractors, and it's this freestanding duty. Prosecutors must exercise diligence to locate and produce evidence from all team members. And there's Erkey versus State. It creates the absolute right to inspect and test relevant evidence. Brady obligations extend to law enforcement held evidence, and knowledge is always imputed to the prosecutor. So even if he doesn't consciously know that there is evidence in the possession of the crime lab or the prosecutor's office or the police, he has to go find it. It requires him to go search out the information. They must proactively seek, obtain, and timely disclose all relevant, exculpatory, impeaching, or mitigating evidence in the possession of them or any member of the prosecution team, including law enforcement and contractors. Contractors, of course, like expert witnesses, as we'll see in this case. The duties exceed the constitutional minimum set by Brady. In other words, Brady is the floor, but in 3914, Texas has set a ceiling. In other words, even if they don't ask, even if it's not exculpatory, you have to turn it over. So it provides much broader protections. I'll simply pull out some of the best arguments in this video because it goes on for quite a while. And with 3 lawyers arguing for each defendant, it turns this into a much longer argument than it needs to be. So I'm going to select just a couple of vignettes from this video and the prosecution's response, and of course the judge's ruling. So at issue in this argument is essentially the admissibility of the testimony of this expert witness, who is a former FBI agent, because in their disclosures, the prosecutors omitted key information. And so let's hear a little bit of what the defense is bothered by from the defense itself.
We were not made aware that Mr. Joyner had any experience as a patrol officer or peace officer in the state. It wasn't disclosed to the CV. Given that we're litigating a case involving peace officers in Texas and how they acted in this particular case, that would have been invaluable information to have for us to investigate and interrogate his qualifications as an expert in this particular area. It would have allowed us to get records from Spring Valley Village as to his employment, what his actual experience is, whether he's had any disciplinary issues there. We've been kind of deprived and caught by surprise now with this witness. There's really critical information that wasn't disclosed to us. We got an outdated, incomplete CV. And so feels a little bit like ambush. So we've come into this trial expecting I'll give it to him, experienced in federal law enforcement, but we had no notice that he had any experience in state law enforcement, which, as Mr. Blunin and Mr. Harrison pointed out, is the focus of this case. It's state law enforcement and their standards.
And, Your Honor, that's particularly important in this case after the people who were sponsoring him told the court that he was wrong and that they were not going to be calling him as a witness.
The prosecutors had a bit of an answer to that, and here is what they said.
May I ask a few questions? Sure. Mr. Joyner, is the CV that may have your state law enforcement experience, is it available on the internet?
I don't believe so. I believe on my website it has one of the older CVs and not the current CV. I can check right now if you'd like.
Please. Your Honor, while Mr. Joyner is looking up for the status of his current CV, I would also note what has been disclosed to defense. Page 6 of that enclosure is listed. He's currently a licensed master peace officer in Texas, that he has been a frequent contributor to the Texas Commission on Law Enforcement, TCLO, that he is a member of the Texas Police Association, and in his previous testimony has testified in state courts on use of force against 4 officers charged and against officers so charged in several states in this district, this county, Travis County, Harris County. So there is a basis to determine he's well versed in the application of state law.
Did you notice that subtle turn of phrase there? They are still hung up on his qualifications. The prosecution is. They think the defense is challenging his qualifications. The defense is not challenging his qualifications. They're challenging the disclosure. And I think the prosecutor knows that. But again, it's an attempt to fog the issue, to make it appear more murky to the judge. And it doesn't go well for them.
And to be clear, Your Honor, my concern is less a matter of qualification, it's a matter of fairness and adequate disclosure of information that we're entitled to under 3914. The very fact that he's a peace officer who ostensibly has TCOL training goes to the very heart of this case. That's information that's in the sole possession of the state. We can't just go get it. It should have been turned over to us as part of the basis for this expert's opinion, and we've received no notice in that regard.
Now, what's not clear here, and I will attempt to make clear, is that his training or actions as a police officer in the state of Texas is relevant. It may not be exculpatory, it may not be impeaching, but it's relevant. And the reason it's relevant is because if there is some skeleton in his closet, well, the defense has to know about his experience in order to go find that skeleton, even if the prosecution hasn't determined that there is one. Again, as we'll see in a minute, the prosecution seems not to understand the rule of 3914.
You guys able to provide that to them?
It's information that we didn't have, Your Honor. Yes, he had been, we had commissioned him for a report. I don't have it. The CV that I have is posted as what was provided to the defense. I
mean, he's testified about law enforcement matters. He obviously worked as a law enforcement officer, but he hasn't provided that information to you?
The fact that he had state law enforcement officer did not come in the initial product, the initial CV. I did not make a subsequent inquiry from him of that. I don't believe it's any intent to deceive anyone. Simply an updated CV came forward with the product.
So what you just heard there was the prosecutor admit that he did not go out and proactively seek this information. And what does Rule 39.14 require? It requires him to go out and search for that information. So they're going to make an argument with regard to the disclosure violation as it applies, and they're going to cite to these cases, Watkins and Heath. Here's a little bit of that.
14, and this, we asked for an addendum to the initial report. I asked for that by email because of the 3914 disclosure, and this witness wrote a report, and he said that he looked at additional videos of Officer Rojas and Officer Ramos. So what we have here is that this witness is now telling this court under oath that he looked at an additional video that's not disclosed in his expert reports. So there's been a failure to disclose information, and we asked what notes existed for Travis Thompson, and he said he had none. And if we take him at his word that he did in fact look at Travis Thompson's video, he failed to disclose that, and the state failed to disclose that in the addendum that we had asked for in the middle of this trial. So, you know, we asked for witness disclosures and expert reports and expert information prior to the beginning of this trial. And we're giving information in the middle of trial while it's ongoing that they failed to give us at the beginning, which we were entitled to under 3914, under due process, and under the Michael Morton Act. So to permit this witness to testify now would be a manifest injustice, and we ask that he be stricken.
And just one point of clarification to kind of piggyback on what Mr. Cifuentes said. I'm not, as to the TCOL information, I'm not suggesting that the prosecutors have it and didn't give it to us. However, they are constructively in possession of any information that the government has. TCOL is a state agency. They would have an obligation under Michael Morton to get that information, whether or not Mr. Joyner volunteered it. The onus, as we all know, having done the job, is to go and procure that information. So if they know, or should know, that he was a state peace officer, that's basic information that either they should have gotten on their own or at least disclosed to us that he was a Texas peace officer so that we could make an appropriate request under 3914. We've been deprived of that ability. We're now in the middle of trial. We don't know what impact that would have had on experts we might have called, on how we might have examined our experts in this trial. We've been deprived of that opportunity. And so I endorse Mr. Cifuentes' request that Mr. Joyner not be allowed to testify.
So now the judge gets involved and he asks, hey, did you guys not think to get this stuff? What's going on here? And in a naked attempt to gaslight the judge, this prosecutor says, we don't have any responsibility to do that. They could have gone and gotten that themselves. They could have issued subpoenas. And of course, that misses the point of these cases and the statute itself, as the judge is about to make clear.
The state, did y'all not think about getting that information, or what's the thought process?
You know, Mr. Harris may have some thoughts. First of all, we went on through this in some of the discovery hearings you might remember before trial. The state has no obligation to turn over things that are not written. Okay, there has to be documents, and there are no documents that he's given us that says I watched some other video, or Travis Thompson's video, and he doesn't have an obligation to write down that he watched a video. So that's not discoverable under Michael Morton. It includes documents, unless it's exculpatory, and it's not. It's not exculpatory. Unless it's mitigating, it's not mitigating. So this kind of demands that the defense repeatedly make that the state knew something and didn't turn it over isn't required under our discovery rules and our statutory rules for that.
It's Brady, right? I mean, potential Brady. Right?
Well,
Potential.
what they've been given, we've been reading the report. It's a report that they've been given, Your Honor. It says, I am currently a licensed master peace officer in Texas. They know that. They have the ability to send out a subpoena and investigate that and get those records themselves. We don't have. We don't have his birth certificate. I don't know if he was born in Texas. We don't have his school records. If he went to attend school, then just because it went to a government, because he's affiliated with government,
We're talking about potential Brady, right? We're not talking about birth certificates or school. We're talking about potential Brady. Anything potentially that could have any sort of Brady material, right? You would be
were you employed?
Yes, you would be obligated to get that, wouldn't you?
If we had it.
If it exists.
Not if it exists. If we have it. If we have it. It doesn't say if it exists. It says if the state is in possession of those items.
I disagree with you. I think it is required. It is required to get that information to see if there's Brady for the defense to look at.
Yeah, okay.
Now the state and the attorneys hassle back and forth about what is involved in Heath and what is involved in Watkins and what the facts of those cases are and how they're distinguishable. Spoiler alert, they're not distinguishable. The mandate is there, it's in the statute, and it's in the case law, and they had a duty to go and get that. So here's what the judge decides.
Mr. Peace Officer in Texas or holds a certification. Goose and Gander, they should have known. It never says anywhere about being employed as a reserve. Where, I don't even know where Spring Valley is. I think it's in Harris County, but who am I going to give? It just doesn't make sense that they're shifting it to us and act like they have no obligation at all, and they do.
And I think, Your Honor, that he speaks specifically to this very circumstance.
Yeah, because it seems like the argument that Mr. Lunan was making was not an accurate rendition of what Heath holds. Am I right about that?
Just the very first paragraph of Heath, the Court of Criminal Appeals states, the question they pose is, does the mandate in Article 3914, the Michael Morton Act of the Texas Code of Criminal Procedure, that the, quote, the state produce discovery, quote, as soon as practicable after receiving a timely request, include discoverable items which, unbeknownst to the prosecuting attorney, are in the possession of law enforcement agencies. The Court of Criminal Appeals says, yes, in this context, the state means the state of Texas and includes prosecutors and law enforcement. As soon as practicable, as the phrase appears in 3914, A means as soon as reasonably possible and does not contain a knowledge requirement on behalf of the prosecution. I'm not accusing Mr. Luna and Mr. Harris of knowing the information and failing to turn it over, but Heath makes clear that they have an obligation, unlike just a generic background check on a civilian witness. When they have a witness, particularly an expert, who was a member of law enforcement of this state, Heath makes clear they have an affirmative duty to seek out that information.
And as much as I'm salivating to cross-examine Mr. Joyner, Judge, I think it's obvious that it's your discretion to exclude him from this jury hearing from him.
I don't know if it's so much a discretion. It seems mandatory at this point.
Fair enough.
So I'm gonna sustain the defense objection. Anything else?
And the prosecutor sits down with his tail between his legs, and he knows that he's been beaten because the requirement is there, plain as day, in the statute, and he didn't do it. It's interesting because this judge has been especially good in this trial. He's played it right down the middle. He hasn't given the police officers any breaks. He hasn't given the prosecution any breaks. He has played it straight down the middle, and you have to respect that in a judge, so kudos to him. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better, that would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.